As we continue our coverage of Jacob Zuma's impending imprisonment, the one thing that some people are wondering is if the former president will hand himself in tomorrow. And if he doesn't, what happens next? What consequences will he face, if any? To help us understand this, I'm joined by legal expert Nthabiseng Dubazana from Dubazana Attorneys. Thank you for your time, Nthabiseng. What does happen next if the president decides not to hand himself in? That's the first part of the question. And the second very important part is what the process he's begun right now, that rescinding process, is there any validity to it?
Well, actually, before this interview started, I actually saw an article that says the Constitutional Court has accepted his application, and therefore the matter is now postponed to the 12th of July for him to be heard. So that is very interesting. But to answer your question, if in a normal criminal court setting, if you fail to adhere to a court rule, which is what is going to happen if he doesn't, bring himself to the nearest SAPS in order for him to start his sentence, then there are orders for the SAPS to go and get you and help you to the police, to the correctional services in order for you to start your sentence. So looking at the order that was signed off by the Constitutional Court acting Chief Justice right now, Ms. Khampembe, she already wrote a committal that he should now then be serving his sentence. I think it is in eNCA. So that was already now in place. So now looking at what if it's true what I just saw, that the matter will be heard on the 12th of July for the rescission application. Therefore, it would mean that him tomorrow not presenting himself to the police station has fallen away. It's kind of irrelevant until the matter is heard again in court in order for the court to deliberate amongst themselves. So you asked about the legitimacy of the application for rescission of judgment. When you look at, I beg your pardon?
I was saying yes, please go ahead. Yeah, that's very important.
Okay. When you look at the dissenting judgment, when Jacob Zuma was sentenced to 15 months imprisonment, and you look at the majority judgment, there are issues, there are parts of the dissenting judgment that I think would probably help or assist this application for rescission of judgment to the Constitutional Court. There are very valid points that Meteron raised when she was drafting her argument. The main things that rights that she mentioned was the right in Section 12 and the right in Section 35. So the right in Section 12 is a right to freedom of movement. So it's about not being detained without a fair trial, being allowed the opportunity to answer to certain allegations that are made against you. And then Section 35 is the right to any person who's a detained person. A detained person has a broad explanation. There was a whole case law, I remember, that had to deal with how to determine or define what a detained person is. So when you look at those aspects that were raised in the dissenting judgment, I believe those are the reasons or the basis of the application for the rescission in order for the court to deliberate amongst themselves as the judges and make a decision whether or not it was the correct kind of sanction to give versus what they currently have given out. Because if it was a concord, a whole all the judges were concurring with each other pertaining to the sentence, we wouldn't be having this discussion right now. But because there was a dissenting judgment, there is some kind of ground, minimal as it may be, that they can make that application and say that the court was not in agreement with itself. So can you please go back together again and look at the situation, reassess it, and then see whether the majority is still correct, or can we now incorporate the minority's assessment of the case?
So it does seem like that really helps the situation. The tensions that are rising have been rising for the last day or so and will continue to rise in Nkandla. It means that what you've just read, as you say, if it is valid and true, it means the pressure's off. Everything's moved till the 12th of July when that hearing happens. And I'm assuming, like you say, the ex-president has to now appear in front of that particular court in order to explain himself and put forward his arguments. That's what will happen next.
Yes, 100%. I'll go back to what a normal setting would be when you're doing, when you've been sentenced as an accused person. You have to put forth what we call mitigating factors. So that's your personal circumstances, your health, all of these things. So in a normal setting, what ought to have happened would have been that once he was sentenced, then they could put forth all these mitigating factors that he's now raising in the application for rescission, whereby he is raising his health issues, his age, and all of these things. And so these are the things that he will now be putting forth in this application. Hopefully it's in the affidavit, the founding affidavit that they're going to submit to the court, but still most likely the court might want to hear viva voce evidence, so basically his verbal explanation of his situation, and then if necessary put some questions to him and then make a decision, or rather deliberate and then make a decision. So it would be quite imperative for him to make himself available and present in court. That way we don't find ourselves back where we are now. He's not there. We don't have answers to this. We don't have answers to that. So I think it is quite important for the 12th of July, if it is true that it's been postponed for then he makes himself available.
And of course that issue has come up again and again. In making the judgment, the acting Chief Justice Kampepes did say that they were concerned that the ex-president was not going to appear anyway. So there wasn't an opportunity to say, well, let's give him another chance, let's ask him to come again. Am I right? I'm simplifying it, but essentially it was he's shown a reticence to appear, he's been intransigent about it, he's not coming, and that's why we are acting the way we are and not saying, can we have another chance? But this time we're saying, well, there is a chance, and he's going to appear, and he's sort of, at the last minute, his attorneys have been smart enough to come up with this particular strategy. Is that correct?
Very, very correct. They were kind of smart there in order to, avoid going to prison as soon as that is. But I think that this could have been prevented. And I'm not even talking about the application for contempt of court. I am talking about the very first time when the commission's attorneys made an application to the court to compel him to testify. I believe the legal team ought to have at least raised in the papers that we cannot be approaching the apex court on this issue when there's a pending matter in the High Court where we are requesting the recusal of the chair of the commission. Can we rather wait? Can the court let that matter run its course and let a judgment come from that, and let the commission then make an appeal to the court, in the constitutional court, based on that? But that was never raised in the application, in the responding to the application by the commission. So the constitutional court could not even deliberate on that one issue. So had that been done, I believe we would not have gotten to where we are right now, because we'd still be waiting for the outcome, the High Court matter.
So if you have to read going forward, 12 July, the hearing happens, they make their arguments. I mean, what possible outcomes are there? 2 or 3, what are they?
Well, usually you cannot change your sentence, If the arguments are usually for mitigation that you made after judgment, right? And then you mitigate before sentencing the accused. So in the match court stroke and the High Court, regional court, all of that, you cannot change what your sentence is. That's why there is an appeal process in order for another court to look at the evidence and come back to a different conclusion, because you're appealing either the conviction or the sentence or both. So in this situation, I don't know how it's going to work. It's never happened before, whereby we are asking the apex court to reconsider the sentence that was already given. Are they going to now set a precedent whereby they're saying, oh no, now once you've made a sentence, you can actually look at it and change it? Because we're going to use that when we are in criminal court from now on. We're like, no, we can change the sentence now because the court has set a precedent. So it's either the court will stick to its current sentence and say, you know what, there's nothing we can do, it's fine, or they will set a precedent and change the sentence in its entirety. Now that will be very interesting to see.
But how can they even possibly do the first thing, which is stick to their sentencing, if they've said, we've opened the door, come in on the 12th? Why come in if this particular first point you're making is inviolable?
That's the thing. My mind is blown. I don't know what is being thought by the court, because in my opinion, you've made your decision. It's over and done with. Whether or not there's a minority and majority decision, the decision is made. So why are we allowing that an accused person that has been convicted to come and challenge a sentence at the apex court? There is nowhere to go beyond this. So what is happening? are we now saying that we are allowing accused persons to challenge the sentence that is made by the courts? Does that mean that from what you're going to do today, on the 12th of July, does it mean that it will filter down to the lower courts? What are we saying as the Constitutional Court, judges? What is the message we're trying to portray? Are we trying to also, rectify the fact that Section 12 wasn't adhered to? A right to fair trial, right to not be detained without, all the rights that you are entitled to. Are we trying to balance that out? Are we trying to apply Section 36 of the Constitution in a reverse kind of way? I am baffled. So that's why, for me, it's quite interesting to watch what's going to happen.
Wow, this is really fascinating because, like you say, it's purely new ground that's never been trod before. That's going to be trod for the first time. So from a legal precedent perspective, this is going to be incredible. What happens on the 12th of July?
I, for one, I'm very excited. If it goes in support of Jacob Zuma, you do understand, as a criminal defense attorney, I will be shouting to the heavens like, yes. But anyway, we'll see how that goes.
So if you had to... Now, we are moving into the realm of conjecture. And, of course, you're a lawyer. You like to stick to facts. What could have... And I know, maybe the answer is nothing. You have no idea. What could have influenced this opening of the door? Do you think political pressure? Do you think they're sitting there saying, oh, my goodness, is the country going to the brink? Perhaps. And maybe it isn't. But is that sort of thing... It should never apply. But do you think that might have a role to play?
Remember, when any judgment that is made in any court, it is the personal circumstances of the accused are taken into account, the seriousness of the offense, and then the interest of justice. These are the three factors that are taken into account when we sentence any person. So now they had decided that the personal circumstances of the accused were not placed before them, so they can't consider those. And then there is the issue of whether the seriousness of the offense. In my opinion, failure to appear is a serious offense, but it's not serious enough to warrant 15 months. And now we also have to look at the interest of justice. Is it truly in the interest of justice to have him committed for 15 months? Because remember, we're trying to get him to testify in the High Court for the arms deal case. We're trying to get him to testify in the commission in order to get somewhere with the commission. Is it truly in the interest of justice, in the interest of justice, that the accused be committed to 15 months? Now, looking at what has been happening in the past few days in the country, in Nkandla and everywhere, could it be that the interests of justice were not carefully considered by the court, and the result of their sentence and their judgment is now the breakdown of society as it's happening so far? Could it be the influence that they allowed him to serve his papers and then hear him on the 12th? Could it be that they have considered that the 15 months was indeed too harsh of a sentence? The sentence didn't warrant for the crime itself. It is... I don't know. It is quite interesting. I don't know what would be the leg on, but for me, I'd probably think it would be the interest of justice factor that is saying that, no, man, they did not consider that properly, not just only the commission's hearing or the arms deal matter or whatever, but the community and the support that he wields or yields within the community. So I think that could have been an influence in making this decision that they open up for him for the 12th of July.